Get ready. This is your chance to ask questions about family law, from marriage to divorce, from birth to death, and everything in between. Call in right now, live, on a special hour-long The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
Tonight is your chance to ask questions. The topic is family law. The number to call is 1-800-375-4049. 800-375-4049. My guests are attorneys J. Douglas Crane and Lynn Crane. Doug, Lynn, thank you for joining us this evening. Now, you both practice family law.
Yes.
And through some remarkable coincidence, you both got the same last name.
Yeah.
Actually, it's not a coincidence. They are husband and wife. Lynn, you, in addition to practicing family law, you do a lot of estate work as a fiduciary commissioner in Monongalia County.
That's correct.
I'm going to ask you the first question everybody always asks me, and you can tell me if my answer is correct, or check it. The first question I hear when somebody comes in to talk about administering an estate after the death of a family member or someone close to them is, how long is this going to take? How long does it take?
Well, it varies. It can take somewhere between 4 to 6 months or a year or longer, depending on when you get your documents filed. If they're filed timely with the fiduciary commissioner or with the clerk to hit advertising deadlines and other deadlines that are set in place statutorily. So I would go with probably at least 6 months. 4 months is really tight time frame.
And if you do it in 4 months, that means everything happens at the earliest possible opportunity, and the dates when the deadlines come up are in sync with the dates for publications of notices in the newspaper.
That's right, and that's very difficult to do. You really have to be on the ball.
I have seen some estates where a document comes in and it's 6 weeks before notice of the administration of the estate is published, because you just missed one deadline and the next one is coming, but it's not here yet. And it sort of kind of revolves around when the first of the month is and all kinds of things.
That's true, because our advertising deadline is the Wednesday before the first Monday of the month, so that varies. And if someone gets it to me on a Thursday and I've already sent my things in on a Wednesday, we have to wait.
And it also depends on whether you can look at it immediately.
That's true.
And I suspect in your practice, as in mine, things don't always happen the moment they came in. I received an email message from a client the other day who said, he sent me the email message at roughly 4 o'clock on a Saturday afternoon. And at 11 o'clock on Monday morning, he sent me another email message saying, have you looked at this yet? No, because there was Saturday and there was Sunday, and then I came into the office about 8:30 on Monday morning, and now it's 11 o'clock, and I've been doing some other things, like seeing how many email messages there are, seeing if there are any letters. So things don't always happen at the first possible moment.
No, they don't.
Doug, you have been on the show many times, especially with these call-in shows. I'm going to ask you the same question I always ask you, and that is, what's the status of grandparent rights in West Virginia?
Dan, as grandparents, and I am one, we don't have any rights in West Virginia. The rights, I know that there's a statute, but it's actually called the grandparent visitation. It's not grandparents' rights. And if you read that statute, the most important thing at the very end says, if the parents agree. So you can set up all sorts of scenarios, but if the parent says, I don't want you to see your grandson or granddaughter, that's their right.
Your right as a grandparent to see or be involved with your grandchildren flows through your child.
Your child, yes.
And if your child has run off or has died, then there is no one there for those rights to flow through.
Well, now, death's a little different thing. You may be able to step into the shoes of a deceased child.
Maybe.
Maybe, yeah. None of these things are etched in stone, so it's on a case-by-case basis that the courts will look at this.
And the real determiner is how well the surviving parent likes you.
I tell people all the time, get along with your daughter or son-in-law. That's the biggest thing. Problem is, once people start filing suit, everybody lawyers up and they start backing up. Yes, get along with your children so you can see your grandchildren.
For future reference, I hate the phrase lawyers up.
But it's very true. You can sit and talk, and then when they start with petitions, I don't know of a better phrase, but
Well, the number one way to get somebody angry with you is to have a lawyer write them a letter.
Yeah.
That's people just, the door closes.
many times.
Well, the phone calls have started to come in. Kimberly in Kanawha County, you have a question for us.
Yes, Dan, thank you so much. I love your program,
Thank you.
and I love public TV. My question is, I am taking care of my elderly mother. I have no siblings, and she has been diagnosed with Alzheimer's disease. Now, the wrench in the works is I have no power of attorney over any of her affairs, and because of the fact that she has Alzheimer's disease, I've been told there's nothing I can do. She doesn't know who I am. Medicare will give me no information about her coverage.
Okay,
I can't talk with her doctors.
The first question we need to ask you, Kimberly, is who told you that there's nothing you can do?
Well, the people at Medicare.
Okay,
because she.
That may or may not be true. Doug, what does it take to be able to sign a power of attorney?
Well, you have to be competent as to ×3, I believe is the medical term.
Person, time, place.
In place. If her mother is at Alzheimer's, she probably can't effectively sign a power of attorney that is valid. However,
There is another procedure or
Right.
something in place. It is a guardian conservatorship that she can get through the circuit court, and she would file a petition with the mental hygiene commissioner. There would be a hearing. There would be a guardian ad litem appointed for the mother, and that generally takes probably 45 to 60 days to get it all the way through.
Let's take a step back from that. Kimberly, if your mother has good days and bad days, she can sign a power of attorney on a good day. And generally, the power of attorney form doesn't have to be witnessed by anybody. She just signs it, and the signature is notarized. But the notary has to be comfortable that the person signing the document understands what they're signing. If she has good days, she can sign a power of attorney, and the odds are nobody's going to challenge that unless you take the authority under the power of attorney and then do something abusive or do something wrong. Generally, children taking care of
especially sole heirs, if she is the sole
yeah,
heir.
and if you're the sole heir, that works in your favor too. But if she's not capable of signing a power of attorney, that is, if there has been an adjudication that she can't take care of her own financial affairs, or if she really is so badly off that her doctors would say she never has a good day, then, as Lynn says, you have to go to circuit court, you
Right.
file a petition seeking the appointment of a guardian, someone to take care of her body if she needs that, and a conservator for her estate to take care of her financial affairs. That is a fairly time-consuming process. 30 to 60 days is not uncommon.
Right. There's a 30-day notice period, and then you have to have a hearing scheduled, but it would be
And lawyers get involved.
not necessarily. She could do that. There are form packets available at the circuit
But
clerks.
the court will appoint a guardian ad litem who is
Right.
typically a lawyer to
Right.
investigate the circumstances.
to represent the potential
yeah,
protected person.
the protected person. And so there's going to be expense associated with that. Now, in your case, that may be what you have to resort to. And the easiest way to know generally how to do that is go to the circuit clerk's office and ask them if they have information for you about seeking the appointment of a guardian and or conservator. They have a packet of information. I think all counties have that now.
I believe they do,
I
yes.
think so.
And you can look at that, and then you can decide whether you need to go to an attorney. If you ask a lawyer if you need a lawyer, the answer is always going to be yes. In some cases, you don't. Get the packet of information, read that first, then decide if you need to go to a lawyer. There is expense involved. It can easily cost $1,000, $2,000 or more to go through that process, which is why we always recommend to people to
Get a power of attorney when they can.
It's
early.
cheap insurance.
Very cheap insurance.
That means right now. For everybody other than Kimberly, and Kimberly, if you haven't signed a general durable power of attorney yet, it's time to do that because something could happen to you tomorrow morning. We should all have them, but they are dangerous documents.
You better make sure the person you give that power of attorney to is someone you trust. Absolutely trust.
And is someone worthy of your trust.
Worthy of your trust, yes.
Also, what we typically recommend is that if you sign a power of attorney document giving the power to handle your affairs to, well, anyone, the one person you do not give that document to physically is the person you name in it. Give it to someone else to turn over to them when the time arises.
A situation that I need a power of attorney yeah.
That's right. There are many different forms for these documents. There's probably as many different opinions about what form to use, what needs to be in it, as there are lawyers in West Virginia or anywhere else. But basically, they all say the same thing: is I give you the authority to handle my business affairs for me as I could do myself.
That's it in a nutshell.
They're very, very powerful, dangerous documents. I have seen them abused.
Oh, you can wipe somebody out in a day, and that's if you're slow.
You
you
get
give
up early
somebody
in the morning and start. You can
completely control of everything that you have and name, place, instead.
Well, of
if
course.
someone's going to abuse it, they can.
If you abuse it, someone acting for the person who has given that power of attorney or who has been abused can challenge the activities, can sue the person who abused it. They are responsible.
Yeah.
But what do you get?
Yeah, especially if the money's gone.
Once the money's gone, the money's gone.
So it's just a word of caution. Be very careful what you do. It is an extremely powerful document, but it's also an extremely necessary document.
A real hot topic that has, it's a really hot topic that's been in the news a lot lately, is this whole concept of marriage and what it is and what it should be and what it can't be. And we've talked before the show started. We all have our own opinions about it. But the real issue is what happens if you're not married? I think everyone understands that when you're married and it comes time to get a divorce, we're going to divide up the property in some manner. We can go into that later if it's appropriate to do that. But if we're not married, if you and Lynn have lived together for 25 or 35 or 45 years and you decide to split up, who gets what?
Well, if you are in agreements, you can work out who
She
gets what.
everything.
Well, to be fair.
But,
To be fair, yeah,
but if
that was-
not, if you're not in agreement, it can end up in civil court, battling over ownership. It can get very ugly. But there's nothing in place to protect people who are just living together and are not married, unless they have taken the time to write up agreements as to what might happen if they would split up to their belongings, or if they own things jointly, where their ownership rights are protected that way.
Yeah, if they own a house and it's joint tenancy, those things can be done. But without the marriage, there are things that are just left out. I think we talked one time about the civil union contract, and I think we can probably get that about 95%. But that thing of marriage is a whole different thing you just can't get to.
The law of each state differs slightly, but basically the law of marriage just kind of puts a set of contracts in place between the couple to accomplish all kinds of things. It defines who can authorize medical care, who automatically gets this or gets that.
It becomes a legal partnership.
A business.
It is a legal partnership between those married spouses.
That's part of the argument about whether same-sex marriage is the right thing to do or is possible, or whether it has to be formalized in a particular way. All of that rather gets in the way so far as lawyers and the state of West Virginia at least see it, because what we're really dealing with is contracts between a couple for the acquisition of assets, in some cases for the production, the parenting of children. And the law has deemed these things to be so important, they really want the relationships to be defined. And when people start living together and having children together without being married, that's a problem. Hundreds of years of law go down the tubes. We're talking about family law, from marriage to divorce, from birth to death, and everything in between. My guests are family law attorneys J. Douglas Crane and Lynn Crane. I'm Dan Ringer, and this is The Law Works. We have another caller on the line, Kay in Monongalia County. You have a question for us?
Yes, hello. I got divorced from my husband last year, and then I started getting notices of financial matters that I had no knowledge of, and I found out that he had filled out a durable power of attorney and made himself my durable power of attorney. And now I'm having to extricate myself from different financial situations, such as non-payment of taxes. And I wanted to know.
He signed your name on a power of attorney form?
Yes.
Doug, Lynn?
That's fraud and forgery and uttering, and that's a crime.
It's also a good reason to go back to family court. I would
Absolutely,
think.
yeah.
Yes, I think so.
Did you have a lawyer in your divorce?
No.
Everybody goes,
As we said earlier, ask a lawyer if you need a lawyer. The answer will always be yes. And we understand the problems with that. But you really and truly should go speak with an attorney, and you should do that now.
and maybe also talk to the prosecuting attorney.
Yes.
Absolutely.
Yes. Thank you. I think I'll do that.
All right.
Okay.
Good luck to you,
Good
Kay.
luck, ma'am.
We see things like that, hidden assets, hidden debts. The fact that you are divorced doesn't mean that you don't owe debts incurred during the marriage, unless there's a court order that says you don't, and even then, you may still be responsible for it.
Well, even more so now with the change in the new bankruptcy law. If it is a domestic obligation, years ago, prior to BATSEPA, the change in 2007?
BATSEPA is the case.
2005.
Yeah.
It's the
2005.
abbreviation for the new bankruptcy
Oh,
law.
I'm
Bankruptcy
sorry.
law.
It's
If you had
2005.
equitable distribution and you didn't like it, you could file bankruptcy and get rid of it. And too bad, I'm not paying it. That's changed.
Equitable distribution is the way we divide up marital assets and debts in West Virginia.
Yeah, and there's, you take this, I take that, and there's always a leveler. I've never had one that just split perfect, and there's always somebody owes somebody boot. So if at the end of our divorce, equitable distribution, I'd owe her $25,000 to level it up, make it even. If I didn't like that, I could file bankruptcy prior to BATSEPA and say no, and nothing she could do about it. Now, one of the first questions in bankruptcy at 341 is, are you responsible for domestic obligation, alimony or child support? Those are generally non-dischargeable.
One of the things that one of our family court judges is doing now is requiring the parties to have a recent credit report and exchange those. And in the case of Kay, who just called in, that might have helped for her to discover some of this during the time of the divorce, so that it would be able to be addressed by the court at that point.
Credit reports are available to you from 3 major credit reporting agencies. Go online, search for credit report or free credit report. Not freecreditreport.com, that's a business. You can get a free credit report from each of those agencies each year. That doesn't give you your credit worthiness number or
No.
whatever that
No, it's
is,
just-
but it will give you a multi-page document that you can print out and review to tell you who claims that you owe them money, who has said that you are delinquent in the payment of debts, and there are mistakes on them. So get these reports. I would suggest you spread them out. You get one every 4 months from each credit agency to make sure you know what's going on. And apparently they're very useful in divorce cases too.
Yes, they are.
We have another caller, Sharon in Mineral County. You have a question, Sharon?
Yes, I was concerning about my grandchildren. I have 3 of them, and the judge had gave me rights to see the kids every other weekend on Saturdays for 8 hours, and their mother took off with them to another state, and I haven't seen them on my weekends. Is she allowed to do that? even though it was court ordered that I see the kids every other weekend?
Well, she would be in contempt of court.
Depending on what the order said. Did the order require the mother to notice the grandmother prior to moving, to change visitation?
No, she did not. She did the same thing in November. She took off with them, took the one out of school, and left with them for 2 months. And the judge told her that she had to bring them back. And he still continued with my every other weekend visitations. And she took off again with them.
Have you brought a petition back in front of this judge to inform the judge what she's done?
I have not, but I have talked to an attorney here in the county, and I can't get a court date until in July.
Well, that's not uncommon. Family courts are extremely busy, and I believe you only have one family law judge in Mineral County, Judge Stotler, I believe it is, and he covers three counties in total. So yes, the court docket would be crowded. One of the problems that we have, not only in West Virginia, but in this country generally, is we just don't have enough family court judges to handle the demands that are imposed for things decided in family courts. Now, the primary problem you have is that you have no inherent right as the child's grandparent to see the child or the children.
Yeah.
But if a judge has said you have the right to see them, then the question becomes, and if you're denied that right, what happens? And it's not a criminal offense. If a parent is denied access to the child by somebody taking them and running off, that can be a criminal offense.
Well, it could be parental kidnapping, which is a felony.
But that doesn't apply to grandparents, does it?
It could be a contempt issue.
It could be a contempt issue. And all the time in family court, I mean, the court can do generally two things. It can take your money and take more money or less money. It can set a schedule for you to see the child or children and expand or reduce that schedule. So depending upon how flagrant this is with the judge, I mean, he could transfer custody. They do a FIG action.
I don't go there.
Well, you mean between the parents or between the parent and the grandparent?
Grandparents. I mean, if she is deemed unfit or constantly...
But that's a very high hurdle.
Well,
Very high.
I mean, I don't know enough facts about this to do that, but for the lady that called it, she needs to get with an attorney, get it filed, so this judge finds out what's going on, because judges don't know until it gets in front of them.
Well, and one of the problems is because there is no statutorily, that is defined under the law, statutorily defined grandparent's right to visit with the child, the parent, who is the bad actor here, could appeal the judge's decision and remove your right to see the children entirely, because our Supreme Court has pretty steadfastly said grandparents don't have any defined rights. Your rights flow generally from the parent, which is at the top of the show. We were saying, be nice to your son-in-law, daughter-in-law, whoever it is, because you may need their support to be allowed to see your children. It's a very tough question, very difficult question.
Very emotional and extremely difficult question.
We have another caller, Fran in Braxton County. Hi, Fran, do you have a question for us?
Yes, I do. I have my will already made out and my medical power of attorney, and the executors of my estate are both out of town, live out of state. My question is, which I didn't ask the attorney, if they can't be here to help take care of all these things, could they turn it over to him, and would he be responsible for paying insurances, taxes, and so forth till the estate is settled, or would that come out of the children's money until things are solved?
Ms. Crane, fiduciary commissioner, right?
There you go.
Explain all this.
Well, if the people that you've named as your executor would elect not to serve as the executor or executrix of your will, then they could decline, and someone else could be appointed through the county clerk's office, but they would have to have a bond put up for the amount of personal property in the estate. The money to pay bills that are estate bills come out of the estate money. It doesn't come out of somebody's pocket personally, it comes out of estate money. So I don't know that the attorney would be the best one to do it. What you might want to do is consider either redoing a will and naming people who are more local to take care of your will, or just work that out.
The qualifying question, the initial question she asked was, does my executor have to be present in West Virginia to do these things? The answer, well, the answer is for one day.
One time.
Yeah.
Yes.
That person has to physically go to the courthouse, answer some questions, sign some forms, and write a couple of checks.
Write a check for somewhere around $50 or $60.
And perhaps post a bond if your will doesn't say to serve without bond. Now, if the person you have named as your executor says, I don't want to, and the alternate executor says, I don't want to, then they will most likely have to sign a paper saying, I give up my right to qualify as executor. Or if they don't show up and do anything for a period of the first 30 days after your death, then anybody who's willing to serve can come in and do it, but they will have to post this bond.
Correct.
And the least it's going to cost them to post a bond is about $100.
Yes.
And depending upon the size of your estate. You had another question for us, Fran?
Yes, I do. Now, I'm getting older, and I have no family around because of the will and everything. What is the law that you put your home in someone else's name if you would have to go to the nursing home so that the estate could be left for children, or is there such a law?
Well, there are lots of laws that apply to this. Do we want to start in the little bitty parts and then spread out?
Ma'am, if you're talking about so that if you would need full-time care, nursing home.
Medicaid care.
Right,
Medicaid.
if I would end up in a nursing home.
Okay, and you own your own home.
Yes, sir.
As I understand the law, then that should be used to pay your medical bills.
Okay.
After your death.
Right.
After your death, they will not take the house while you're still living, even in a nursing home, because there's maybe a chance you'll get better and go back to your home. So.
Okay.
And it also is, the state of West Virginia has the option to come in and put a claim against the estate, and a lot of times if it's under a certain amount of money, they don't pursue it. Used to be there was around a $50,000 cap before they would come, had to be at least 50 or higher before the state would come back in and seize assets of the estate.
The law that we're talking about here is referred to as the Medicaid Recovery Act. And Congress, in its finite wisdom, said that if people have spent their life acquiring assets to take care of themselves and their family, and then they reach a point in their life where they need those assets to take care of themselves, we're going to direct that the Medicaid people can come in after your death, and if you're married, after the death of the second of you, and sell the house to pay toward or to pay off the health care costs that you incurred during your life. And Congress had said that's fair, that's the way we think it should be. And there's good arguments on both sides of that.
It's actually a reimbursement. Those bills are paid, and they may not get reimbursed until years down the road.
Yes, Medicaid is being reimbursed for having paid your bills. Now, if you give your house to your child, what are the consequences of that? Well, first, it has to be far enough in advance of your needing nursing care to keep.
Right.
And right now, I believe it's 60 months. A
5 years.
Look back period, yes.
That means that if you give the house away within 60 months of needing nursing care, Medicaid is going to presume you still own the house, that it can be liquidated, and you can apply that money, and they will not help you. Also, if you give the house to your child and it's not where they live, when they sell the house, they're going to have to pay taxes on the money difference in the value of the house when you got it and the value when they sold it. And that can be a substantial amount of money. The alternative to that is to simply leave them the house in your will, and then if they sell the house, their tax burden is much, much less, and maybe zero.
Zero, yeah.
It could be zero.
Should be close to zero.
So these are very tricky questions. There are lots of things that are designed to help avoid that, such as living trusts and things like that, but
the average person does not need a living trust. I mean, they're...
I don't like those.
Yeah.
I really don't.
they sound very attractive in those TV ads that you see, but as a practical matter, most working lawyers aren't very fond of them.
They cause more problems than they solve.
Oftentimes, yes.
Oftentimes.
They certainly can.
They certainly can. And most people don't understand why when we've talked to people and they come up with these things they've seen on the internet or on TV or whatever, and they're all set to do this, this, and this. And I said, well, what is it you're trying to achieve?
I want to protect my home from being taken by the government.
Yeah, yeah. And there's ways of doing that without going to the trust and things to protect them and for their children, and so children can inherit.
We have another caller, Glenn in Monongalia County. Welcome, Glenn. Do you have a question for us?
Yeah, thank you for taking my call.
Certainly.
I have a twin brother and an older sister who live out of state. Now, if I should get seriously ill, do I have to choose someone in West Virginia as my power of attorney, or can I choose one of my siblings?
Are you referring to a general power of attorney or a medical power of attorney?
Medical power of attorney.
Okay.
They do not have to live in West Virginia. They can live wherever, but as a practical matter, it might be better to have someone who was closer to make those decisions, who could be here on a daily basis and talk with your physicians or healthcare providers.
One of the things go ahead, Glenn.
Go ahead. I'm sorry. Can I choose a friend?
Absolutely.
You can choose anybody.
Anybody that you trust.
Okay.
And who understands your wishes.
Yes.
That's very important.
Now, does the person have to be present in West Virginia or at your bedside? Well, not for a lot of things, but for some things, yes. An authorization to perform a medical procedure is probably going to need to be in writing. Now, it's going to depend on the physician or the institution as to whether they will allow that signature on that document to be a copy of a photograph, such that you might send the form to the person in another state, they would sign it and then fax it back to you or email it back to you. Usually you want original signatures on those things, so you don't want to create the situation where you're going to have a 2 or 3 day delay because of the mails.
Yeah.
And with a medical power of attorney, there's also the possibility of it is an emergency. So you need someone who can actually be there and make decisions at the time they're necessary, as opposed to even faxing things back and forth.
Yeah, now I don't think it applies in Glenn's case, but for an awful lot of us, when you go into a doctor's office or into the hospital, they'll look at you and say, do you have a medical power of attorney? And the implication is you have to have one, or you really ought to have one, or they expect you to have one. As a practical matter, the law, at least in West Virginia, is that your spouse can authorize medical treatment for you. Nothing has to be in writing, that just has to be your spouse. And if your spouse is not available, your children can make decisions for you. The problem occurs when you have an even number of children and they are divided as to what should happen, and you have a 2-2 split or a 1-1 split or something like that. So the West Virginia Medical Association and the West Virginia State Bar got together and they created a committee and said, let's figure out a way to solve this. And the document that we typically refer to as a medical power of attorney was created. We're talking about family law, from marriage to divorce, from birth to death, and everything in between. My guests are family law attorneys J. Douglas Crane and Lynn Crane. I'm Dan Ringer, and this is The Law Works. I knew I was going to stumble over a word somewhere in there. Why do we worry so much about having these authorization documents, medical power of attorney and things like that? Why can't the doctors just do what they think is best?
Because what they think is best may not be what you want done. You may not want to have heroic measures to resuscitate or keep you alive, or the doctors may say, well, let's do this procedure, but the question is it actually necessary? So you need somebody who knows what you want to be there to help protect your wishes.
Today's technology, you can probably keep someone, quote, alive, whether they want to or not. I mean, you know, whether they're brain dead.
We don't even know what alive is.
I know, I mean, but so that again, each individual should have some input into his or her desires and wishes and wants. And if they're incapacitated, how do they convey that to their doctor, to their hospital,
and so
to
often,
their medical power of attorney?
And so often we see cases where I talked about a 1-1 or a 2-2 split among children.
Oh.
Children really do disagree about how their parents
Absolutely.
should be treated, how medical issues should be handled.
And I mean, diametrically opposed.
And that's why if you have your children being co-power of attorneys for you, you need to sit them down and say, this is what I want, and explain it to them very clearly.
And get them to acknowledge that that's what they'll do.
Exactly.
Yeah.
So we use paper to do that. We have another caller, Betty in Harrison County. Welcome, Betty. You have a question?
Yes, I do. I was just wanting to know, I am married and have been married for 38 years, but there's some problems. If I was to get a divorce, would I receive half of everything that we have accumulated?
In general terms,
In general terms, when people get divorced in West Virginia, equidistribution says you'll get 1/2 of the net assets acquired during the marriage, barring any separate property or inherited property, as long as you didn't do it. So 1/2 of the net assets acquired during the marriage would be equidistribution.
the devil is in the details.
And it doesn't matter whose name it's in. If Lynn and I were getting divorced and everything was in my name from the date we were married, she'd get half, or vice
Would he
versa.
have to continue paying, or I just get half and that's it?
Ah, now that's the details.
That's the second question is you're talking about, those are assets. You're talking about a question of spousal support. That's a whole different issue.
Okay.
And there are 14 different criteria that the court looks at. Length of marriage, health of the parties, how long you actually live together. I can't remember all 14 right off the top
Earning
of my head.
capacity,
Earning capacity, what your health is, what his health is.
whether additional education would help you increase your earning capacity.
yeah.
There are lots and lots of issues. And when we say the net assets of the divorce, you've got marital debt out there as a cloud over the marriage, and everybody has some kind of debt. We take the assets, the net value is the fair market value of everything you've got minus the money that you owe to other people, and then the court will say, husband, you pay certain of these debts, wife, you pay certain of those debts, and then the question arises, well, what if one of them doesn't pay their part of the debt? You may still be on the credit card or whatever it is. Are you excused from paying it?
The single biggest thing you see is when one buys the other one out of the house, out of the marital home, and I'm going to buy her out and I'm going to hold her harmless. That's what it says in the divorce decree.
So she stays on the debt papers.
Because the bank is not bound by my divorce decree.
Right.
The bank says when we were together we had 2 incomes and they would now they won't make me a loan on my income alone to pay that mortgage payment. They're not going to let her off.
So you would still be responsible
If he
for
didn't-
making the house payment on the house that you don't own anymore.
Correct.
Yeah, I don't know that. And it would show up on her credit report that we talked about earlier. Because that
And-
debt has not been removed.
And the horror of our recent economic unpleasantness is you might be able to sell the house, but you may not get enough money to pay off that debt, and you're still going to be paying on a house not only that you don't own, but that nobody you know owns.
Yeah. That's true.
And then they do a short sale, which has its own problems.
Which once again goes to the, yes, you can go to the circuit clerk's office and you can get a stack of forms to fill out that will get you divorced and that will report at least part of your financial status. But oh, please, if you've got any alternative, don't do that. Hire a lawyer to get you divorced. It is the biggest economic undertaking you will ever follow.
Especially if you have considerable assets. I mean, that it's extremely important.
Well, and considerable assets don't have to be large amounts of dollars. If you don't have any money, $1 is a lot of money, and $10 is a considerable amount of money.
And it's easier to get it right the first time than try to go back and fix it, because sometimes after it's over, it may not be able to be fixed.
There are problems.
Huge problems. And it generally costs twice to 3 times as much to try to fix a
Try
problem.
to fix it later.
I do not know a family law lawyer who does not agree that they make more money fixing bad divorces than they do getting good divorces in the
It's
first
so much
place.
more time and intensive involved. You got to work like heck to get to ground zero.
It is easy to tie your shoes. It is difficult to get the knot out of your shoes and then tie them. It takes
correct.
more time, and in a lawyer's office, time really is money. Another caller, Debbie from Kanawha County. Debbie, you have a question for us.
Yes, I do. I was wondering what is involved with a name change for a minor child and if you need an attorney.
It depends on the reason for the name change.
Yeah,
in large part.
and the minor child, if the minor child would have to have both parents. I've seen this attempted when somebody, it's now a stepdad, and they're going to change it. You can't do that. I mean,
No, the parents were never married, and the father's name is on the birth certificate. I'm the grandmother. My daughter really wants to know.
Is she wanting to change the child's last name to her family
For her
name?
last name. Hmm.
How does the father feel about this?
We don't know. He's incarcerated.
Okay.
Oh, that's a problem.
This
Probably
is,
not good.
This is something that has to go in front of a circuit court judge. You file a
Right.
petition for a name change. The father is noticed for that and has the opportunity to object, has the opportunity to delay the hearing. The court might appoint a guardian ad litem for the incarcerated person to represent their interests. And I've actually been involved in one of those that we couldn't get the name changed.
The general rule in West Virginia is that a father whose child bears his last name has a valuable interest in that child having his last name. It's not something we can define monetarily, but the father has a right to have his child bear his name.
And without his consent, to change it.
No, once it's on the birth certificate that way.
Yes, once the child has his name on the birth certificate, that's the way it is. And it takes his consent to change that. If you can't find him, well, that adds a different wrinkle to it. The question is, has he been paying child support? Has he been in contact with the child? Has he sent presents and things like that? It's very much an analysis like abandoning a child.
They know where he is.
He's incarcerated. So
And if you know where he is,
he's prohibited, I mean, from doing things. Yeah.
in fact, you probably can't even bring the action while he's in prison unless a guardian ad litem is appointed for him.
That's true. That's exactly.
If he's incarcerated for a period of more than a year, I think that rule is triggered. And I'm not even sure in a name change if a court would entertain that, because usually what we're talking about in suing inmates is whether you have an interest in the inmate's estate and whether the right to have a child carry your name is a part of it. There are a lot of questions.
It's actually, you're not suing the inmate, but you're filing a petition to change the name. And yes, the court in Monongalia County will appoint a guardian ad litem. I've done this, so yes.
But it didn't work.
It did not work, no.
And we also have to caution that there are 55 counties in West Virginia and a couple of hundred judges, and each judge is different and
unique,
and sometimes you get different results. Well, we've had a couple of calls this evening talking about grandparents' rights to see children. Under the letter of the law, grandparents have no rights except through their children to see their grandchildren, but some judges are saying, okay.
Some judges are saying, okay. Those cases have not been appealed to our West Virginia Supreme Court, as you said.
Not the ones we're familiar with.
Not the ones we're familiar with. And a lot of family court judges are going simply with what they think is the best interest of the child or children. And sometimes grandparents are better off than the biological parents.
Well, and there's kind of a general rule that kind of floats in a cloud above the law, and that is the justice system tries to do the right and fair thing. And because sometimes that's not easily discernible, we end up writing down hard, fast rules to say this is the way to do it. And sometimes judges will look at those hard, fast rules and say, well, I'm going to change it a little bit.
You have competing interests, and they're just diametrically opposed.
And when you're dealing with kids, the overriding rule tends to be what's best for the child. And judges will try to do that.
Yes, they do.
And legislators try to do that.
And there's no definitive answer. You can't get 2 and 2 is 4 and say, absolutely, this is best for this child or children. It is a judgment call. That's the problem.
We're talking about family law, from marriage to divorce, from birth to death, and everything in between. My guests are family law attorneys J. Douglas Crane and Lynn Crane. I'm Dan Ringer, and this is The Law Works. Well, the judge that we hold up as the paragon of wisdom, the best judge that has ever existed, was Solomon, and they took the child in front of him, and they both said, that's my child, I want my child, and what did he do?
Offered to cut the baby in half.
Was that in the best interest of the child?
He didn't really do it.
We've been backing off from that.
Yeah.
Even in that case, when the judge said, that's what we're going to do, we've been backing off from that.
Yeah.
Doug, you were we call him family law judge now. What was it called when you were?
Oh, family law master.
Family law master. It was kind of a quasi-judge. Were you surprised sometimes by the things that you saw?
Yeah. Yeah, I mean, it is amazing. And I always made this statement, especially when you're dealing with children. You make decisions based on what you have. And I can tell you if my decision was right 10 years later, because you don't know what you're faced with the time you make a decision of custody for a mother or a father. And it's hindsight will give you a great answer, but at the time you don't have that luxury.
And people will, To paraphrase Art Linkletter, people will do the darndest things.
Yes, they do.
When it involves their children, they will say and do things that decent people would just never think of doing when they're in their right mind. We have another caller, Gary in Greenbrier County. Gary, you have a question?
Yes, sir. Good evening. Thanks for taking my call.
Surely.
I have been married. I have my second marriage. We've been married for 9 years, and I owned my home for at least 17 years or so before I got married, and this is my second marriage. Now, my first marriage, I have 2 children, which are grown and of age and all that, and I'm looking at trying to have my will redone to where if something would happen to me, my current wife would be able to stay and live in this house until her death or her decide to leave it to protect her. And I was wondering what's the best way to look at that or approach that.
Pretty much what you just described.
Yeah, you've
that
done,
works.
That works just fine. And I assume then after that, sir, after your current wife passes or whatever, then does this house then go to your children by the first marriage?
Yes, sir. It would go to my children or someone in my family.
Okay.
Okay, let's take a step back. How long have you been married?
We've been married for 9 years.
Your wife is entitled to 27% of your estate by virtue of the fact that you are married to her. That's the minimum amount she's entitled to. Mm-hmm. So if you have lots and lots of assets, she could in fact end up with the house through the probate process if your estate is worth so much that the value of the house is less than 27% of the estate. But that's not an absolute. There's a lot of give and take, push me, pull you involved in all of that. You can write a will that says, I give my wife a life estate in the house, and in general terms, that's fine, that's okay, and then you can say upon her death it goes to Tom, Dick, and Mary, or Curly Moe and whoever else, if that's what you want to do.
Yeah,
okay.
Absolutely.
But please don't go to a office supply store and pull a form off the shelf and try to put something like that into it.
No, I was planning on sitting down with an attorney here very soon.
Yes.
And I was just wondering what the law of West Virginia was and what was if I was approaching it the right direction.
I think you're approaching it right, but make sure you give all the facts to the attorney you're going to talk to so that he or she can give you the best advice based on the facts of your particular case.
Okay.
You cannot exclude your wife from getting anything. She is entitled to what's called the elective share.
Yes.
You do not have to leave your children or anyone else anything, but you must provide something, we say for your wife, for your spouse, because it's a two-way street no matter what the situation is. This points up the necessity of being completely open, truthful, and forthright with your lawyer.
Oh, if you don't tell him or her all of the assets and things are left hanging, you may validate your entire will. Again, on the elective share, I'd rather give no advice than bad advice. And if you don't give you all the facts, you're just blowing in the wind. I mean, it's dangerous.
When you die without a will, you are said to have died intestate. How is your estate distributed in that circumstance?
Well, intestate, the state of West Virginia has set out a statute that says if you die...
Very specific about
Very
that.
specific. First of all, and I'm going from memory now, would be that if I die, if I have no spouse, then it goes to my children. If I have no surviving children. If I have no children, basically it goes down, then up. So if I have no parents that survive me, and I have no children, and it starts going sideways to cousins and nieces and nephews.
Siblings.
Siblings and brothers.
So generally what it is the current spouse would be entitled to, I believe it's 50% of the intestate estate. And then
if you've been married for 15 years or more.
There's,
3% for each year of marriage, up to 15.
Then you go back to surviving children from a prior surviving children, and then they would inherit the remaining amount if they are surviving.
If there are any.
Basically, if you're married at the time of your death and all of your children are with your spouse, then everything goes to your spouse.
Correct.
If you have children by someone other than your spouse or or in another relationship, your spouse gets a part of your estate, depending upon how long you've been married, maybe 50% of it. and all of your children then share equally in the remainder of your estate.
Surviving children.
Surviving children. If you have no children and you have no spouse, then half goes to your father, half goes to your mother. If your mother or your father is deceased, all of it goes to the surviving one. If you have no mother and father, then it starts to go to your brothers and sisters. And if you have no brothers and sisters, then it goes to your father's and your mother's brothers and sisters. And it can get to be very complex.
Yes.
Yeah.
If you have been successful, don't die without a will.
Yeah.
We have another caller, Jeff in Roane County. Jeff, good evening.
Yes, good evening. My question is, when it comes to divorces, in our end of the state over here, we have this epidemic of third parties, advocate groups getting involved in divorces on part of the female. And
what kind of groups are we talking about?
well, the group specifically is called a group called EVE, Eliminating Violent Environments, and they're partly state funded, and they rely on donations. They will pay lawyer fees for the female, and I've talked to people in the state about this, and I've been told by 2 female lawyers that no lawyer or politician is going to touch this issue because it is either it's professional or political suicide. And I'm just wondering, and it really factors in around here. The lawyer I had that represented me in my divorce was from Jackson County, and she told me that, she says, you think it's bad in Roane County, you ought to see Jackson County. And she even quit taking their cases because she said, I don't like the way they do business. And I've had 2 Roane County lawyers. One said, well, you think it's bad here, you ought to see Calhoun County.
Okay, your basic concern is, can a third party come in and pay for somebody else's representation in a divorce and perhaps help them find a lawyer who'd be sympathetic to their cause?
Yes, well, that, and
well,
it's also
there's absolutely nothing wrong with that.
Well, but they also advocate stuff like squirrel away money, get a credit card in your name, which when the divorce goes down, you're probably stuck having to pay part of that.
Possibly.
Not necessarily so, but possibly.
Possibly. There are a lot of things that factor into a divorce, and one of the real problems that we have in our society is domestic violence. And it sounds like these are groups that are organized around that concept and trying to help people out. So, and they're present in every county of the state.
Yeah.
There are domestic violence shelters. In the northern part of West Virginia, we have the Rape and Domestic Violence Service, who actually they do a lot of very, very good work. Now, tactics that are sometimes used in divorce, squirreling away assets, yes, that sort of thing happens. That's what the divorce process is all about. That's why we advocate getting credit reports, getting bank statements. All of these things are used to identify hidden assets. Sometimes that can be very difficult. If there's some way to divert cash to a bank account in Aruba, I suppose you can do that, and it's hard to identify those. But basically, you heard us refer earlier in the show to a marriage as a business. Each partner in that business really needs to pay attention to the ebb and flow of money in the business. So if money all of a sudden starts to disappear, they need to start asking questions.
Absolutely.
There's no easy answer to that. Hiring a lawyer for somebody who can't afford one or can't find one, that happens all the time. In fact, lawyers volunteer to do that kind of work pro bono, we say, for free, because of the importance of it sometimes.
Yes.
I haven't seen militant advocacy groups in my practice, but I've only been practicing for 35 years. They may be out there.
I've not seen that around here to that degree.
We say around here, we're talking about north central West Virginia,
yes.
basically. Well, I think we've run out of time to take phone calls, and those of you who are still on the line, and I understand there are a lot of people on the line, we apologize. Maybe we ought to consider doing something like this more frequently than once a year. It sounds like there's a great demand for it. You can, if you would like to suggest a topic for a program, we have a Facebook page, we have a web page, and we have an email address. The email address is thelawworks@comcast.net. You can search for us on Facebook. The web address is thelawworks.org. You can send us email messages. You can send us private messages. I suggest you not post to the Facebook page because that's an open forum, and just don't do that. And we'll consider your request. By the way, if you suggest a program topic that we ultimately put on the air, we'll send you a t-shirt. Lynn Crane, Doug Crane, thank you very much for being with us.
Thank you for having us.
Thank you for being with us also. On behalf of the Law Works, this is our 361st show. I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes. The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law.
The Law Works is made possible by major grants from the Office of West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975, which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.